This is Deep Dish on Global Affairs, going beyond the headlines and critical global issues. I'm Brian Hanson with the Chicago Council on Global Affairs. And this week, we're looking at Supreme Courts around the world and comparing the roles they play in democracy. 2 weeks ago, the U.S. Supreme Court overturned Roe v. Wade in a highly controversial decision. This was followed by far-reaching rulings on gun control, religion in school, and climate regulation, all of which triggered questions, at least by some, about the legitimacy of the court and its role in our democracy. Now, transformational decisions by the Supreme Court are really nothing new. It's ruled on everything from the minimum wage to civil rights to same-sex marriage, and decisions have steered the direction of our country and touched almost every aspect of American life. Yet in some ways, the highest courts in other constitutional democracies appear to be more restrained. So, how much of an outlier is the U.S. Supreme Court among the highest courts in the world's democracies, and why? What are the implications for democracy? Are there patterns for when Supreme Courts act as bulwarks for democracy and when they facilitate democratic backsliding? Finally, what lessons might other countries offer the United States Supreme Court and its role in our democracy? To help us answer these questions, I'm joined today by two experts. Here with me is Tom Ginsburg. Tom is the Leo Spitz Professor of International Law at the University of Chicago, and he currently co-directs the Comparative Constitutions Project, an effort to record and analyze the constitutions of all independent nation states since 1789. Tom's also the co-author of the book, How to Save a Constitutional Democracy. Welcome to Deep Dish, Tom.
Happy to be here, Brian.
And we have with us Dan Brinks. Dan is a professor of government and law and is the chair of the government department at the University of Texas in Austin. He's also active in the fields of comparative politics and public law. Welcome to Deep Dish to you as well, Dan.
It's my pleasure. Thank you for having me.
I want to start our conversation with really the fundamental issue of what role a Supreme Court or our Supreme Court plays in democracy. And I was wondering, I'll start with you, Tom, if you could give our listeners a quick primer on, what is its role in our democratic system? And particularly one of the striking things about the Supreme Court is that it's inherently counter-majoritarian, right? It's 9 judges in our case making decisions who are unelected, who are making decisions in a democracy. What about the court bolsters democracy, and how does it work in our system?
Right. So for our system, there's sort of 2 major roles that the court plays. The first thing is that, of course, our system's a federal system and has been since the beginning. And anytime you have 2 different lawmakers, like a state and a federal government, you do need some kind of arbiter to figure out when, one is overstepping on the lawmaking power of another. And so that's always been a traditional role of our Supreme Court. The other thing, of course, though, that's more closely related to democracy is the idea of rights, right? The idea that, even a democratic government shouldn't impinge on certain fundamental interests like freedom of religion or freedom of speech, or in our country, something like the right to bear arms, that those individual level protections are things that we need a special body to stand up for. And it's for that reason that the court is sort of supposed to be counter-majoritarian. That is, it's supposed to block the Democratic majority when the Democratic majority would infringe on these core interests. And, I think in theory, that really makes democracy possible, because when people's core interests are protected, they're much less likely to, worry about government really, really hurting them. So I think there's kind of logic to it, at least in theory.
And Dan, let me bring you in. And like Tom, you've studied courts around the world. What are some examples of other cases where courts have really played the kind of positive role that Tom just talked about in supporting democracy?
Right. So I think it's interesting to think about that, in particular, that second part that Tom was talking about, right? And like, how can we all sort of accept defeat in ordinary elections, right? But not be so worried about it that we're willing to kind of just live with the loss and fight another day. And courts that have sort of provided that function, I think almost any court since what you would say the third wave of democratization in Latin America, especially, I would say, right? A lot of those countries until the 1970s, 1980s, right, viewed an electoral defeat as an existential threat, right? So a threat to your core interests that was so deep and so profound that you might call on the military to intervene and to prevent the other side from taking away your stuff or your freedom or whatever it was, right? And I think a lot of the countries that emerged from that sort of civil conflict in Latin America, including some that are still pretty troubled today, right, set up courts that were really seen as arbiters of this new political settlement. And Tom has written about this in his book, right? Countries like South Korea, in particular, I think have had courts that have done well, but in the places that I look at in Latin America, the court in Argentina, the court in Brazil, the court in Colombia, in particular, after 1991, right, that was a moment of a sort of deep civil conflict, a lot of uncertainty and unrest about the future of the country, and I think creating a constitutional court in some ways helped to reassure people that their core interests were protected so that they could kind of go forward with ordinary disputes about ordinary policy, right? The stuff that we can disagree about without feeling like we're going to lose everything.
And building on that, Tom, what are other courts that you also see as having played Supreme Courts that played a particularly positive role in supporting democracy in their countries?
There's many examples. A really well-known one is the German Constitutional Court, which under its constitution has a special role not only in protecting rights, which have a very high status in their constitution, but also in policing the boundaries of politics. So actually in that country, they have banned a couple of political parties, the Nazi Party after World War II and the Communist Party, because those parties were not truly committed to democracy. So that's kind of an interesting role that we see some courts in some countries play. Courts in other countries will police elections. The Indian Supreme Court has played a very important role in fundamental rights. The South African Supreme Court has played a really important role in holding the government, particularly of Jacob Zuma, accountable for, really excessive corruption. So there's lots of roles courts can play beyond simply, the main role of protecting rights. And one of the things we've observed in recent years is that if courts have become more powerful around the world, we observe constitutions giving them more and more additional roles, such as, monitoring political parties or policing elections or even reviewing legislation before it's passed, things like that.
And why is that, the strengthening of these courts?
Well, I think it has to do with the idea that, courts have become really more important in the politics in many countries since the end of the Cold War, particularly. As democracy spread, you needed an independent arbiter. You needed a institution to police politics, if you will. And as courts' sort of reputation rose around the world, they were given more and more jobs. Because, you always want to give the job to a neutral third party rather than a partisan body. Now, talking about this in 2022, I think we're starting to see the wheel turn a little bit on this, as courts in many countries now have been viewed as maybe a little more partisan than that neutral imagery would lead one to believe.
So I want to pick up right there, because that is, of course, the charge that's made against the current U.S. Supreme Court, is that it is becoming a more partisan actor, and some would say advancing minority rule in some of the policies decisions that has made recently. So I've frequently heard it said that the U.S. Supreme Court actually plays a bigger role in U.S. politics than Supreme Courts do in many other countries. Dan, I was wondering kind of how do you see that issue? Is that a fair characterization? Obviously, it's a generalization. There are going to be exceptions. But is that a fair characterization? And why are there those kinds of differences with the role that the Supreme Court plays in the U.S.?
Yeah, I think you have to make a really clear distinction between the courts in the advanced Western democracies in Europe and places like that, from courts in what we now call the global South generally. I think courts in the global South, because of the dynamic that Tom was referring to a moment ago, have become much more important political actors in lots and lots of different countries, right? The constitutions in those countries assign sort of courts a lot more tasks. But even if you stick with sort of rights protection, right, they just create a lot more rights and they give people a lot more rights. And they often charge courts, not always, but they often charge courts with enforcing those rights. And so, in a lot of countries around the world, in the global South, there's this kind of robust social, economic rights constitutionalism that is entrusted to the courts, and courts have done a better or worse job of managing that in different places.
And what are some examples of some of those rights? Because not all our listeners may be familiar with them. What are some of those things?
I mean, certainly the one that I think has generated maybe the most judicial activity has been the right to health and the right to health care, right? So whereas, when public health matters come to the court in the United States, it's really a question of, can the federal government even do something about this, right? In other countries, including South Africa, Colombia, Argentina, Brazil, but also India, other places, right? The question is the government doing enough? Does the government need to do more? And in a lot of those cases, right, the courts have really charged the government with doing a lot more than it was initially willing to do. So that's one big one, but there are lots of others, right? In South Africa, the right to housing has been really important in different kind of iterations of that. Environmental rights have been a huge issue in lots of different places, especially maybe in Latin America. There are other indigenous rights, right? So rights to some limited form of self-rule and territorial control. Those are issues that are coming to the courts all the time.
Terrific. And Tom, how do you see this issue of kind of where the U.S. Supreme Court fits in the constellation of global courts and its role in our political system?
You go all the way back to Alexis de Tocqueville in the 1830s, and he observed that in the United States, and at that time rather uniquely, there was scarcely any political or social question which didn't make its way into the courts eventually. And that's back then. Obviously, that trend has continued to the point where, the courts are this week telling us, where we can, whether states can restrict guns, the answer is no. Whether states can restrict women's controls over their bodies, the answer is yes. And it's obviously become very, very enmeshed in core questions of American life. The U.S. Supreme Court may have been the first in this regard, but it's obviously been followed by courts in many, many other countries. Where I think we are distinctive is that the courts really play such a prominent role in our life in ways that are really distinctive, in part because the 9 justices of the Supreme Court are some of the very few people on earth who can expect to govern for the rest of their lives. As I wrote in one article, you have the Pope, you have the Ayatollah, you have the 12 apostles of the Mormon Church, and then you have the 9 justices of the Supreme Court. And all those people can expect, in most cases to die in office or only to retire voluntarily. And most other countries, which have now very powerful courts, have either limited terms or a mandatory retirement age of 65 or 70. So you don't get this phenomenon of appointing someone at a very young age and then having them govern for 50 years, which is what we're facing right now. So I think that renders the United States Supreme Court rather unique. It creates tremendous focus on individual justices and their personalities and their quirks. It doesn't really treat the court as a collective body very well. And I think it's a real challenge to the legitimacy of the Supreme Court at this time in our political history.
Right. I would add something to that as well, which I think kind of compounds the challenge, right? So in a lot of these other countries, not only are the judges time limited in their terms, right? But they're often selected through a sort of supermajoritarian process, right? That tries to ensure either because different political bodies appoint different justices so that you have kind of this corporate representation on the court, or because you need to have like the approval of the minority party, or you need to have some weigh-in from the citizens in some cases even, right? And so there's a sense in which the selection of the justices is designed to try to produce justices that respond to a wide variety of constituencies, right? Whereas in our case, right, we've even since we abolished the filibuster rule, we've narrowed it so that it actually takes fewer interests at stake, right, to appoint a justice of the Supreme Court than it does to pass ordinary legislation, right? So that makes the court sort of easily captured by one faction of our politics, right, rather than a body that's inclusive of many different factions, right? And when you kind of sort of match that politicized appointment process to the life tenure, which extends those narrow preferences indefinitely over time, right? You really have a mechanism that imposes the desires, the wishes of a narrow slice of our politics, not just on us today, but on the next two generations of American voters, going forward.
Yeah, which raises those issues that Tom just referenced as well about the legitimacy of the court. And I want to explore this a little further about both the legitimacy of the court and the role that it can play in a democracy. At the beginning of this conversation, we started by the positive roles that the court can play in order to assure a healthy and functioning democracy. We're now kind of starting into the territory of ways in which Supreme Courts can be problematic or even contribute to the erosion of democracy. And to kind of kick off this conversation, Tom, I want to start with you because in the book that you co-authored on constitutional democracy, you say if you look at the U.S., the conventional wisdom is that our Constitution, the checks and balances between the branches, robust civil society, the media, individual rights are going to hold our democracy in place and that it's very robust. And you argue that for a greater extent than many realize, that actually the U.S. Constitution's text and the Supreme Court jurisprudence makes democratic erosion more likely, not less likely. What do you mean by that, and how does that play out in the U.S.?
Right. I mean, I think Americans tend to fall into the trap of American exceptionalism. Our Constitution is the oldest, our country's the best. There's no risk of the kinds of things we see in backsliding countries around the world happening here. And, obviously that view is outmoded. I don't think anyone believes that anymore, given what we've seen in the last few years, a violent attempt to overthrow the electoral process, packing the courts in a sense, or manipulating the process depending on the party that's nominating. So, we seem to be in some danger here. And the Constitution is not a help. It lacks things that Constitution writers today, if they were writing a Constitution, if we were to start over with the U.S. Constitution, we would include all kinds of things that, they didn't think of in 1787. And if you think about it, that's quite natural, right? We don't drive around on horses and buggies, and we don't, write with quill pens, I sometimes say. So, why should we be stuck with governance technology that's 200 and something years old? Well, the answer is constitutional stability is a good thing. But the fact remains that governance technology is woefully out of date. Just a couple of examples. A new constitution written today would have special bodies protected in the Constitution to ensure accountability and oversight of political institutions, counter-corruption commissions, human rights commissions, ombudsmen, things like that. Constitution today, if we were redrafting the United States Constitution, I assure you, we would not give the power to run elections to state legislators, who Madison didn't think would be partisan, but it turns out they really are very partisan. And in fact, we have a major case coming down in the fall in which the Supreme Court is going to take a look at independent electoral commissions, possibly. The case is Moore v. Harper. The theory here is that when the Constitution says that the elections will be held in the times, places, and manners determined by state legislators, that's the only actor that can make electoral rules. Well, that doesn't make any sense. That's the literal, analogy is the fox guarding the henhouse, because the partisan state legislators want to lock in their own position. So why on earth would you do that? No one would do that now. You would have an independent electoral commission. You'd have independent redistricting commissions. You'd have courts playing an active role in policing elections, but we don't have that. So that's a real example of how things can really, set the stage for backsliding. And if you permit me, I want to add one more example, which is rights protection. Our Constitution is full of rights, and we tend to think that they're highly protected. They're not very well protected, honestly. Remedies in the Constitution are undersupplied by courts in the United States today. If the, police were to come in to this interview and arrest all three of us and throw us in jail for a month, our constitutional rights would be violated, and we might be vindicated after years and years of litigation, in which, the people who actually held us responsible wouldn't pay a dime. They'd be insured by, some city government and such. There's just a lot of constitutional violations that just go unremedied. And, we're talking, you and I, in the city of Chicago, of course, where we had a torture ring that took 20 years to, hold accountable, even when everyone knew it existed. So that's another weakness of our system compared with others. So all those things, I think, make us very vulnerable, and I worry a lot about it.
So, Dan, in terms of the vulnerability of systems and the roles that courts can play, negative roles that courts can play in eroding democracy, what would you add to that? And have you seen examples in other places? I mean, I think the election rules that Tom mentioned is one place that could be very vulnerable. I don't know, is that true in other places as well?
Yeah, no, I think that's clearly true. I mean, in most places, right, the electoral system, the electoral bodies, the electoral authorities are fully specified in the constitutional text, right? They come with, and they come with, budgets and people and protections and so on, right? And so that's possibly, I think, the greatest silence in our own constitution relative to what is the norm in constitutions today. But in some ways, right, the very thing we were talking about earlier, the fact that in lots of different countries, constitutions are sort of more highly regulate both political and social life and economic life, and then entrust that to a court to police, to monitor, to maintain, right? If you capture a court that has that much authority, then there's a lot more damage you can do. And we've seen that in different countries, right, where captured courts begin to abrogate term limits for presidents, for example, and allow presidents to extend their tenure indefinitely, where courts begin to, even courts that by some measures were very independent, right? Like the Turkish court 20 years ago or something, right? But that really sort of policed the boundaries of political contestation, ruling out some parties that had a lot of public support and sort of keeping politics within a narrow range of preferences that really violated, I think, the preferences of a lot of public. So there are different ways in which courts can be used to promote backsliding. The most obvious is, I mean, judges and prosecutors are, at least in part, we think of them as protecting rights, but they're really kind of designed to put people in jail, right? So so you use them to put your opponents in jail quite frequently if you have control over them. There are lots of different ways. I mean, the key sort of, I think, is whether the court is susceptible to capture by by a populist or authoritarian leaning leader. And then the court can become pretty easily a tool for moving the country away from more democracy.
So if these are some of the challenges and the concerns that exist not only in the United States, but we've seen happen in other places around the world, what can we learn from other countries, their experiences, and that can be applied to this country in order to be able to address some of the challenges and shortcomings in our Constitution here? Tom, I'll start with you. Are there things that others have to teach us?
This last year, the Biden administration had this presidential commission on the Supreme Court, which was not supposed to recommend reforms per se, but supposed to canvass various possible ideas. And one of the interesting things about that process is that even lawyers who were very close to the Supreme Court, those who argue before it, even lawyers who are coming from the Republican side of the aisle, seem to agree that some sort of term limit would be a good idea, an 18-year term, a really long term. And there's lots of questions about how you would go about doing that. But I think that's really important. And I think that's better than packing the courts or anything like that, because that's a short-term solution which will lead to escalation. But institutionally, when you have the long view of American history, a term limit would be a great thing. So I think that's one lesson we really ought to learn.
Terrific. Dan, what do you see out there that we should incorporate or consider?
Yeah, I mean, setting aside questions about what the Constitution would permit us to do, right? And people tend to kind of throw up their hands at the impossibility of ever amending our Constitution, certainly in the current context. But setting that aside, I think I really like the term limits idea, the 18-year term limits, because it eliminates this kind of randomness in who gets to appoint justices, right? And so it will ensure that over time, the court will be a little bit more reflective of the broader trends in our democracy, because you won't have sort of this sudden appointment of a bunch of justices by one particular faction or party. The other thing I like in a lot of systems is what I was referring to earlier, a more super majoritarian, a less purely majoritarian mechanism for appointing judges, right? So something like the filibuster rule that we used to have, right? But then, of course, you get the problem of minority parties sort of vetoing any potential alternative. And in that regard, Uruguay had a really interesting rule, right? So Uruguay appoints justices to the Supreme Court in a joint session of Congress by a vote of 2/3 of all those present. And if you don't get to 2/3 within a certain amount of time, then the most senior judge on the Court of Appeals goes up automatically to the Supreme Court. And that gives you kind of a reversion point, right? So if you fail to agree on a consensual judge, then at least you get somebody who has a long trajectory, who has a lot of experience, and who's beyond the control of either party. So that's, in some ways, right, one way to ensure that you don't, that you're sort of shooting for justices who can gather widespread support. And if you can't get there, then you kind of get this random assignment, right? That, I think, coupled with term limits, would provide more turnover on the court. I mean, I think it's interesting to think while we're thinking about sort of pie in the sky solutions, right? of expanding the number, right? I mean, 9 is a decent number. I don't hate the number 9. I like it better than 5, right? There's some countries that have even 3, but
Or
having
didn't we start off as 6, I think, in the United States back in the day? Yeah.
Yeah, so having a larger Supreme Court would also sort of take away some of the emphasis on personalities, take away some of the the significance of each individual appointment, the weight of each individual appointment. So thinking maybe about a larger court. I don't think that I would go all the way to India, where there's a really big court that sits in distinct benches. But I think maybe going up to 12 or something might not be a bad idea.
Yeah, I think one of the things that's interesting to me about the suggestions that you both have made is that they seem to me to be possible legislatively, right? Dan, you'd mentioned how hard it is to create a constitutional amendment in the United States, which is truly difficult. Last time we did it, I think, was 1992 or something. But these are things that could be done legislatively, which, we have a hard time with that in our country right now, too. But at least opens up more possibilities. So far, we've talked about kind of technical things that can be done, structural change that can happen. And I guess I'm wondering, ultimately, does it come down to popular politics about what is possible? Is it possible to create some sort of technical set of rules which can protect democracy so that courts can do this? And obviously, some are more likely than others, so it's not that it doesn't matter. But to what extent can we rely on these mechanisms? And to what extent does it depend on actual popular politics? Tom?
There's an old argument about the U.S. Supreme Court dating from the 50s, which says, even though the court is supposed to be counter-majoritarian, that in the long run, they do follow the majority. And that's been debated, but I think there's something to it, that the courts are responsive. It just takes a generation or two, for them to catch up with where the country is. And maybe that's good. It sort of slows down, movements that might be too rapid between one side or the other. The problem, of course, is now with lifetime appointments and young bench, that they may not catch up for a century or half a century. And that just seems too long in a world that's moving really quickly. So I don't think there's any substitute for popular mobilization. We shouldn't rely on the courts. They're not going to get us out of this mess, whatever mess you think we're in. And that means, that we have to continue to engage. I think politics in the United States, as Dan said before, is shaped by the fact that it's really difficult to pass legislation. It's a lot easier to go win a court case. And especially when you have an activist court and your side's, in power. So, but that's kind of, if you think about it, a little bit lazy and not necessarily enduring if you really want to change the country.
Yeah. There's this famous judge, Learned Hand, right, who said a long time ago, he said, I think people put too much confidence, too much weight on judges and constitutions. He said, when liberty dies in the hearts of men and women, no constitution, no court can save it. And I think he's right. I think courts are really good mechanisms for helping us monitor, enforce an agreement, right? Like a political settlement that we're all sort of on board with. But if we give up on the basic agreement, then there's no court that's going to save us from that, right? So I think we do have to take care that in our politics, we really are sort of still engaged in a common enterprise. And then we can have a court that will help us sort of abide by the terms of that common enterprise.
And given what we've got in this country, which is so much polarization and a search and and difficulty identifying a common enterprise, we've talked about how the most recent decisions have raised questions about the legitimacy of the court. What happens if the court loses legitimacy? What should we be paying attention to here, and what are the consequences for our democracy? And to mix things up, Dan, let me start with you on that.
What happens if the court loses legitimacy? I mean, so the the power that the court has, in a way, is the power of its legitimacy, right? The court can make the court can make binding decisions about the things that really matter, about the meaning of our Constitution, about what we can and cannot do in politics, about how we can and cannot live our lives, because we let it, right? Because we say the court decided and we're going to go with that, right? If the court utterly and completely loses legitimacy, right, then it loses the main source of power that it has, right? How that manifests in our politics is hard to imagine, right? I mean, it could manifest in the kind of widespread defiance and non-compliance that you saw in the South, for example, after Brown v. Board of Education, right? Where you have state legislators saying, as long as we can legislate, we can segregate, that sort of thing. So you could imagine it sort of working itself out in really divergent kind of politics at the state level. You could see it play out in widespread public disobedience of court mandates, that sort of thing. And maybe even, I mean, what some would call a constitutional crisis, right? If the executive says, you know what, we don't care what the court said. The court made its ruling, now let it enforce it, and goes forward anyway, right? So you could imagine a number of pretty significant negative consequences, and then the repercussions of that, right? The kind of social unrest, the protests, the unrest that follows. So.
Tom, how do you think about it?
Well, first of all, I'd say that the court's legitimacy actually, on average, is about where it was a few weeks ago. That is, it's risen among Republicans, it's dropped among Democrats. But that, of course, means that its legitimacy is a kind of a partisan legitimacy, not one that is grounded in the neutrality of law or the kind of general application of law. The fact is, most judicial decisions in this country are not at all made by the Supreme Court. They're made by state Supreme Courts. They're made by courts of appeals, which are in fact the final court for many questions in the federal system, most questions in the federal system. So, I think the law may survive, but I do think there's grave consequences of the Supreme Court becoming viewed generally as just another partisan forum. That's been the trend the last few years. Everything has become partisan. You see advertisements for, Republican insurance companies, you know what I mean? And claims that, the mainstream, their media environments are obviously completely segregated. And, I just don't think that's very good for the court. I don't think it's good for law. And I don't think it's good for the country. How we get out of it, that's a much bigger question, because any step that you take is going to be viewed as, just another escalation in the partisan warfare.
So I want to close by asking you each to share with our listeners what they should pay attention to. You both have studied courts around the world and seen them move in positive directions and in negative directions, reinforcing democracy, undermining democracy. Based on that, the long experience and the broad view that you have, in the case of the United States, what should our listeners be paying attention to with respect to the U.S. Supreme Court and its role in our democracy? Dan, I'll start with you.
Well, I mean, the research on how judges behave and so on would suggest to us that the court is going to moderate at some point, right? I mean, that we would expect these justices to do more of what Roberts is trying to get them to do than what apparently they did in this last term. Right. So one thing to look for, I think, would be to see if there is actually a moderation in the decisions in the coming terms. I think that the difficulty we have right now is in kind of divining whether what we're seeing in this term is going to continue and going to continue the court's sort of trajectory that was set now. And I don't know the answer to that. I would have said 2 years ago, 3 years ago, I would have said, oh no, they'll calm down, they'll moderate. They got sort of the big things they wanted. Maybe they'll take a step back. But it's not clear to me that the current set of justices who conform the majority are cut from the same cloth. And so I guess I would look to see how they decide. I mean, that's not everybody will be looking there anyway. I'm not telling any secrets, but I think that's what I would look for.
And Tom?
My view is that, looking comparatively across, many years of history, we see that when courts get too out of step with the mainstream of society, there are pressures to discipline them. Court packing plan in the 1930s didn't succeed, but it sure pulled the courts back from some of the jurisprudence they were engaged in. And there's other things that Congress could do, taking cases out of the jurisdiction of courts or shaping their working environment. So politics has a way of coming back in these situations. What I really worry about is that this court has the ability to create its own environment through cases like the one I described before. That is, if you decide that state legislators can, as was proposed this last cycle, bypass and ignore the decisions of their voters and send their own electors to Washington for a presidential election, well, then you're not in a democracy anymore, are you? When those legislators can draw their own districts and control their own, conditions. And we have a couple of states now in the United States where the state legislators are really skewed towards one party, even while the general electorate is about 50-50. That's the end of democracy, and that would actually impede, given our federal system, the ability of Congress at the national level to act to correct a court that had really, was way out of touch and was engaged in minority rule. So I think that's the nightmare scenario. The better scenario is that politics responds, people come out and vote, and, steps are taken to signal to the court that their jurisdiction will be limited somewhat, or there may be institutional changes. And historically, those kinds of things seem to have worked.
Yeah. Let me add one more thing to what I said earlier, which is I think it's one thing to say the court is not going to help us anymore. The court is not going to broadly define LGBTQ rights, or the court is not going to understand equal protection the way we would like it to be understood, and that sort of thing, right? We will lose the court as an ally. Versus the court is now going to prevent certain matters from actually being a matter of politics at all, right? Ruling out. So some of the rulings on, say, the permissibility of federal regulations kind of tend in that direction. To say, look, the federal government, we're going to come up with a big list of things that the federal government just can't do at all. Right. And so not only could you have, I think the nightmare scenario that Tom is talking about is where the court is really sort of shaping the political process to produce the outcomes it wants. Right. The sort of intermediate, but still kind of nightmarish scenario is where the court is defining the scope of politics in a way that prevents us from using politics to do the things we think are necessary. Right. And then sort of maybe the least bad case is where the court is just not helping us when we want help.
Dan Brinks of the University of Texas at Austin and Tom Ginsburg of the University of Chicago, I want to thank you so much for being on Deep Dish to help us understand the U.S. Supreme Court in the context of Supreme Courts around the world.
My pleasure.
And thank you for tuning into this episode of Deep Dish. If you're looking for more Deep Dish, please take a moment to tap the subscribe button in your podcast app so you can get each and every new episode as it's released. You can find our show under Deep Dish on Global Affairs, wherever you listen to podcasts. And if you think you know someone who would enjoy today's episode, please take a moment, tap the share button, and send it to them as well. As a reminder, the opinions you heard today belong to the people who expressed them, and not the Chicago Council on Global Affairs. This episode is produced by Kira Daring and Ian Whitaker. It's edited by Joe Palermo. I'm your host, Brian Hanson, and we'll be back soon with another slice of Deep Dish.